Hello, everyone. Welcome to Real Estate Principles 5 Encumbrances. And I want you to think of the word to encumber and what that means. Today, what we're going to be learning and our objectives is you'll be able to distinguish between a voluntary lien and an involuntary lien. Identify the persons entitled to a mechanic's lien or a construction lien. Describe the notice requirement applicable to a mechanic's lien. Define an attachment, a judgment, and a writ of execution. Describe the bankruptcy proceedings. You're going to list the type of easements and licenses and describe how they are created. All right, let's jump right in. Abstract of judgment, attachment, bankruptcy, CC&Rs, cloud on the title, condition, covenant, deed restriction, the defendant, dominant tenement, easement, easement appurtenant, easement by condemnation, easement by implication, easement by necessity, easement in gross, encroachment, encumbrance, equity, express grant, express reservation, general lien, homestead, homestead exemption, injunction, lien, involuntary lien, judgment, license, marketable title, mechanic's lien, notice of cessation, notice of completion, notice of non-responsibility, preliminary notice, restriction, encumbrances to real estate. An encumbrance is anything that has an effect on an owner's fee simple title to real estate or use of the property. Some limitations on property use benefit property owners. Property use is often regulated by deed restrictions and other devices of control. Deeds to property in most housing subdivisions require that owners maintain property improvements for the benefit of all property owners in the subdivision. Government controls, such as zoning ordinances, also serve to regulate property use for the public good. Because it can limit the transferability or use of property, an encumbrance may affect the property's value. A marketable title to real estate is one that a prudent buyer would accept. Certain encumbrances will not affect the property's marketability, but others will, meaning that the property will not be worth as much as long as it is burdened by the encumbrance. There may be a cloud on the title. This means that there is some reason why the owner's interest is less than perfect. With a cloud on the title, the property may not be marketable, or it may be marketable only at a reduced price because of the questionable title. A careful buyer may demand that the cloud be removed before title to the property is conveyed. The quitclaim deed is one way in which a cloud on the title can be cleared. This unit examines many possible encumbrances, including liens, judgments, easements, deed restrictions, and encroachments. One of the most important impediments to good title to real estate is the lien. A lien is an encumbrance that makes property security for the payment of a debt or discharge of an obligation. A general lien applies to all property of the debtor, and a specific lien applies only to identified property such as a parcel of real estate. Examples of liens include the following: the judgment of a court general, a financing instrument, such as a trust deed specific, the mechanic's lien given to someone who helps improve property specific. It would be much more difficult to finance land purchases and building construction if a lien on the real estate were not possible. A lien also may be used to refinance a loan, borrow additional money, or initiate a line of credit. The fact that land and improvements to land can be used as security gives lenders and builders some guarantee of payment. A voluntary lien is one agreed to by the property owner. A mortgage or deed of trust that an owner of real estate gives to obtain financing is an example of a voluntary lien. An involuntary lien is one that is imposed without the agreement of the property owner. Involuntary liens are made possible by laws that prescribe ways in which unpaid debts can be used by creditors or government agencies to create the burden of a lien on the property. A tax lien, for example, is an involuntary lien that arises from a taxpayer's obligation to pay real property taxes, state income and estate taxes, or federal income, gift, and estate taxes. Tax liens will be covered in Unit 11. Some other forms of involuntary liens are mechanics liens, judgments, and attachments discussed in this unit. Mechanics lien. The mechanics lien is used to help secure payment for any labor, service, equipment, or materials used in the construction of improvements to real estate. The mechanics lien is an important protection rooted in the California Constitution. It is considered so important any contract provision that purports to waive the right to a mechanics lien has been held to be against public policy and thus void and unenforceable. A mechanic is anyone who performs work or furnishes the material used in the work. Persons entitled to a mechanics lien include all those who work or supply materials at the request of the property owner, or any contractor, subcontractor, sub-subcontractor, architect, builder, or other person placed in charge of all or part of a project. A mechanics lien is available to the following: material suppliers, contractors, subcontractors, equipment lessors, architects, registered engineers, licensed land surveyors, machinists, truckers, laborers. A mechanics lien thus can be claimed by a subcontractor, such as a plumber, electrician, or roofer, even though the property's owner never dealt directly with the person claiming the lien. One way to guard against possible claims is to require that the contractor obtain a payment bond. The bonding company compensates the owner if the contractor defaults in the performance of contract obligations, such as the payment of workers and suppliers. Important notice and filing requirements are specified by law for making a mechanics lien claim. The summary shown here should not be used as the sole guide as to when to initiate a lien. As with any form of legal action, the advice of an attorney experienced in such matters should be sought first. Enforcement and termination. A mechanics lien may be terminated by the claimant's voluntary release of the lien. A lien release should be filed with the county recorder to prevent a cloud on the owner's title. A mechanics lien must be enforced within 90 days after the filing of the lien claim. If credit is extended, notice of the extension must be filed within 90 days after filing the lien, and the extension cannot be for more than 1 year after completion of the work. Enforcement of a mechanics lien is by foreclosure, which will bring about a judicial sale of the property. The lien holder is paid out of the proceeds of the sale. The owner receives only what remains after all claimants have been paid. Preliminary notice. Notice of the right to file a mechanics lien should be made within 20 days of the time the work begins, or the materials are furnished. A direct contract with the property owner serves this purpose. Otherwise, a preliminary notice is hand-delivered or sent by first-class registered or certified mail to the property owner, general contractor if any, and construction lender if any. Preliminary notice need not be given by someone who is under direct contract with the owner, performs actual labor for wages, or is entitled to a lien or payment bond. Starting time. The starting time is the date the construction project begins. The starting time determines when the preliminary notice, if required, must be given. Completion time. The project is completed when work stops and the owner or owner's agent uses the improvement. The owner or owner's agent accepts the work. Work has been stopped for 60 continuous days, or the owner has filed a notice of cessation after work has been stopped for 30 continuous days. The notice of completion may be filed by the owner with the county recorder within 10 days after the work is completed. Filing time. A mechanics lien for unpaid work or materials is filed with the county recorder. If notice of completion or cessation was not filed by the owner, all claimants have 90 days after completion of the work of improvement to file the mechanics lien. If notice of completion or cessation was filed, a contractor of all or part of the job must file the mechanics lien within 60 days from the filing date of the notice. Everyone else has 30 days from the filing date of the notice in which to file a mechanics lien. If you didn't authorize work on your property, you must post and record a notice of non-responsibility within 10 days. Notice of non-responsibility. What protection does the owner of real estate have if unauthorized work is begun on the property? The owner can post a notice of non-responsibility in a conspicuous place on the land and record a copy of the notice with the county recorder. The same procedure may be followed by anyone else having an interest in the land, such as the holder of a lease, who notices unauthorized work being done. The notice of non-responsibility must be posted and recorded within 10 days of learning of the construction, repair, or other work. The notice of non-responsibility must include the following: a property description, the name, address, and property interest of the person giving notice, a brief statement that the person giving notice is not responsible for any claims arising from the work. Example: a landlord who manages and lives in a small apartment building on Seaside Street saw a contractor's truck outside. When the landlord inquired, a worker responded, "The building is being remodeled. The landlord never agreed to remodel it." What can the landlord do? As soon as possible, but at least within 10 days, the landlord should post a notice of non-responsibility at the entrance to the building and file a copy of the notice in the county recorder's office. How to stop a lien foreclosure. A property owner who disputes the correctness or validity of a mechanic's lien can stop the foreclosure on the property. The owner must file a lien release bond in the county recorder's office where the lien was recorded. The bond must be issued by an authorized California surety. The amount of the bond must equal 150% of either the entire claim or the portion of the claim allocated to the parcel sought to be released. The amount of the bond will be available to cover the lien claimant's possible recovery, including costs of bringing legal action. A lien release bond also can be filed by anyone having an interest in the property, such as the lender, or by any original contractor or subcontractor affected by the claimed lien. Exercise. G is general contractor on the Bigelow building remodeling job. G signed a written agreement for the work with B, the property's owner. B, a wealthy but eccentric individual, decided halfway through the project that the design was all wrong. It has been 2 months since the project was stopped by B, and B has not filed either a notice of completion or a notice of cessation. G is owed a considerable amount for materials furnished and wages paid. What can G do? Attachments and judgments attachment. The plaintiff is the person who files a lawsuit against a defendant. Sometimes the plaintiff has reason to believe that the defendant will try to sell or conceal assets that might be awarded by the court to the plaintiff if the case is decided in the plaintiff's favor. At the plaintiff's request, even before the outcome of the case is decided, the court may order that title to real or personal property of the defendant be seized and held by the court as security for satisfaction of the potential award to the plaintiff. This process, called attachment, is restricted primarily to cases involving a business, trade, or profession. Judgment. The judgment of a court is its determination of the rights of the parties to a legal action. The losing party has the right to appeal the decision to a higher court. After the time for appeal has passed or an appellate review has taken place and the lower court's judgment is affirmed, the judgment becomes final. The judgment could take effect as it was originally made or as it was reversed or amended by the higher court. The higher court could also order a retrial and vacate the original judgment. A judgment granting money damages may come from a California or federal court. The court of another state cannot render a judgment affecting California real estate. A final judgment will become a lien on property of the judgment debtor when it is recorded by the party to whom it was awarded. An abstract of judgment can be recorded in any or all of the state's 58 counties. After it has been created by recording, a judgment lien is effective against all non-exempt real property of the debtor located in the county of filing. This includes any real property acquired within the term of the lien, which normally is 10 years. Homestead property, which is covered later in this unit, is an example of exempt real property. Writ of execution. Any non-exempt property or exempt property, as the court decides, may be sold to pay a judgment debt. The lien holder requests a writ of execution from the court, which directs the sheriff or other officer to sell the property. Discharge of debt. A judgment lien may be discharged before the end of its term by payment of the total damages owed. This results in satisfaction of the debt. Notice of satisfaction of a debt should be filed with the clerk of the court. Partial payment of money owed could result in a release as to some but not all of the property of the debtor. P sued Q in a California court, claiming that P had been defrauded by Q of $100,000 in a real estate scam. P won the lawsuit, and the judge awarded P damages of $100,000 plus interest. Q did not appeal the decision but has not volunteered any money to P. Now what? P can file the judgment in any county in which Q has sufficient property to cover what is owed. If Q persists in ignoring the judgment, P can ask for a writ of execution to sell enough of Q's non-exempt property to cover the award. Bankruptcy. Bankruptcy is a federal court proceeding. There are various forms of bankruptcy identified by their chapter in the Federal Bankruptcy Code. In a Chapter 11 reorganization, the court approves a plan to repay creditors. In a Chapter 7 liquidation, the court takes possession of the assets of the debtor and sells the assets to pay off creditors on a pro rata basis. Under Chapter 13, the debts of an individual who earns a regular income are reduced. A debtor may voluntarily petition for bankruptcy, or an involuntary petition may be filed by the debtor's creditors to force a liquidation and distribution of the debtor's assets. In a liquidation, a trustee in bankruptcy holds title to the debtor's assets. The trustee is responsible for the sale of the assets, as necessary, and issues a trustee's deed to the buyer of real property. Some property is exempt from sale, and all property is subject first to the claims of lien holders. Easements. The encumbrances already discussed in this unit affect the transfer of title to real estate. Other encumbrances affect the condition or use of property. An easement is the right to use the land of another for a particular purpose. Easement appurtenant. An easement usually is the right of the owner of one parcel of land to travel over an adjoining parcel. The land over which the easement runs is called the servient tenement. The land benefited by the easement is the dominant tenement. Unless the deed creating it specifies otherwise, an easement appurtenant belongs to or runs with the land. If the dominant tenement is sold, the new owner has the same right to use the easement that the previous owner had. If the servient tenement is sold, the new owner takes title subject to the easement. The fact that there is an easement will be recorded as part of the seller's deed or will be obvious from an inspection of the property. Example, R owns property that R divides into two lots, Lot A and Lot B. R sells Lot B to S and S builds a house on Lot B. The deed to S conveys an easement over R's driveway so that S can get to and from Lot B. The following illustration shows the location of Lot B in relation to Lot A. If S sells Lot B, the new owner also will be entitled to use R's driveway to go to and from the road. If R sells Lot A, the new owner must allow the owner of Lot B to use the driveway. Easement in gross. Even though an easement is a real property interest, its use may not be attached to ownership of another parcel of real estate. An easement in gross is a personal right to use land. The right belongs to an individual, a person, or business corporation and is not appurtenant to any ownership interest in land. The instrument creating the easement in gross can be made binding on future owners of the land, in which case it will run with the land. Sometimes a railroad's right-of-way is an easement in gross. The railroad does not own any adjacent land but has the right to travel over the land on which the easement lies. Pipeline and power line easements are other examples. When an easement in gross is owned by an individual rather than a business entity or public agency, it usually is not assignable by its owner and terminates on the owner's death. Creation of easements. The owner of land may execute a contract that provides an easement right over the land. The recipient of the easement right may or may not be the owner of adjoining land, depending on the type of easement created. Other ways in which easements can arise are discussed next. Easement created by express grant or express reservation. An easement may be created by express grant or express reservation in a grant deed. The wording of the deed will depend on whether the grantor is to be the holder of the dominant or the servient tenement. The owner of the land that will be the dominant tenement will reserve an easement right in the deed to the new owner of the land that will be the servient tenement. Example. In the previous example, if R had sold Lot A to S and kept Lot B, R would have reserved an easement over S's driveway to get to and from Lot B. How to create an easement. An easement may be created by contract. Express grant from the owner of the easement property. Reserving an easement over land that is sold. Implication of law. Long use or condemnation for a public purpose. The owner of the land that will be the servient tenement will grant an easement right to the new owner of the land that will be the dominant tenement. Example. In the first example, R sold Lot B to S and granted S an easement. Only the fee owner of the servient tenement can grant an easement whether the easement is per tenant or in gross. Once an easement per tenant is granted, however, the owner of the dominant tenement can convey the easement along with the land it benefits. Easement by implication of law. In some cases, the law will imply an easement to travel over someone else's land. If a subdivision plot map shows streets, an easement to use those streets is an easement by implication of law. Suppose landowner sells a parcel of land that can be reached only by traveling over another parcel of land also owned by A. It is evident from examining both parcels that landowner has used the easement for many years. Even if landowner A doesn't specifically grant the right to use the easement, the right may be implied by law. Factors taken into account include the nature of the easement, the length of time it has been used, and whether it could be considered permanent. Another form of easement by implication of law is the easement by necessity. A tract of land may be landlocked, that is, there may not be a road adjacent to any part of it. The owner of such a tract has an easement by necessity implied by law over any land of the seller that is adjacent and provides access to a roadway. If the seller owns no land adjacent to the landlocked parcel, there will be an implied easement over the land that provides the most efficient road access, even though that land now belongs to a stranger to the transaction, provided both parcels were once owned by the same person. Easement by prescription. An easement by prescription is acquired in much the same way that ownership of land is acquired by adverse possession. The major difference is that to acquire an easement, property taxes need not be paid. An easement use will become a legal right if it is open and notorious, not hidden in any way. Continuous for 5 years. Hostile to the interests of the owner, without permission, and under some claim of right or color of title. Some easements benefit property owners. Easement by condemnation. Fee ownership of land may be acquired for a public purpose by the government's power of eminent domain. Rights to use land also can be acquired by eminent domain. The creation of an easement by condemnation begins with the condemnation of the right of use on behalf of the holder of the new easement. The easement use acquired, such as an easement for utility line installation and maintenance, may benefit the land over which the easement runs. In such a case, compensation of the landowner may not be required. Other uses, such as a railroad right-of-way or construction of major power transmission lines, are likely to require payment to the owner for the loss in value to the property caused by the easement. Termination of an easement. There are many ways to terminate an easement. They include the following 8 actions. Express agreement of the parties. This may be accomplished by quitclaim deed from the owner of the dominant tenement to the owner of the servient tenement, or from the owner of an easement engrossed to the owner of the land over which the easement runs. Lawsuit. An action to quiet title can be brought against anyone claiming an easement. Abandonment of a prescriptive easement. Although a prescriptive easement is acquired after 5 years of continuous use, it also can be lost if the easement is unused for 5 years. This is not true of an easement obtained by grant, unless the additional conditions described next are met. Estoppel. Regardless of how it was acquired, an easement may terminate if it is not used and the owner of the dominant tenement reasonably indicates that no further use is intended, and the owner of the servient tenement makes use of the land in reasonable reliance on the representations of the owner of the dominant tenement. If all of these conditions are met, the owner of the dominant tenement will be prevented or stopped from complaining of the new use. 5. Merger of the dominant and servient tenements. When the owner of either dominant or servient tenements becomes the owner of both properties, the easement is extinguished. The easement can be revived by a subsequent sale of the dominant tenement. 6. Destruction of the servient tenement. 2 buildings may share a common wall, called a party wall. The owner of each building has an easement over the other's property to the extent that the wall intrudes on that property. If the buildings are demolished and the wall destroyed, the easement terminates. 7. Adverse possession. If the owner of the servient tenement performs the conditions for adverse possession as to the land over which the easement lies, the easement right of the owner of the dominant tenement will terminate. 8. Excessive use. An easement can be terminated if the easement's use is improper or much greater than originally intended. The owner of the servient tenement could object, for instance, if land sold for residential purposes was used as a gravel pit and noisy, dusty trucks began to use the easement. You can remember the ways to terminate an easement by the following acronym Adam E. Lee. Abandonment. construction. Adverse possession. Merger. Express agreement. Lawsuit. Estoppel. Excessive use. License to use land. As you learned in Unit 3, the right to use land may not be an ownership right. Instead of being a freehold interest, it may be a leasehold interest. It also may be an easement, as you have learned in this unit. One more way to transfer a right to use land is by a license, the permission given to another to come onto one's land. A license is a non-exclusive right, which means that the person to whom it is given has no right to exclude others from the owner's land. A license is personal property rather than real property and temporary rather than permanent. A license may be terminated at any time without prior notice. An example of a license would be the permission given by an owner to neighbors to store their lawnmower in the owner's garage. The neighbors are not charged for this privilege, nor does the owner give them exclusive use of the garage, but retains the right to tell them to remove their lawnmower at any time. Under this arrangement, the neighbors have a license to enter the property to retrieve and return their lawnmower. They have no easement, lease, or other interest in the real estate. Example: Explorer H returned home to California after a 6-year absence. H went directly to H's house, a palatial but unoccupied building on 20 acres of land. While touring the property the next morning, H was surprised to find a new power line running across the back of the land, a conspicuous and unwelcome addition. H also noticed a dirt road cutting across a corner of the land to the highway from a little house just off the property. Can the power company put up such a line? By what authority? The little house in this exercise is located on a roadway. Can its owner create a new road across H's property? How? Restrictions. Any form of restriction is a limitation on the use of land. The most common private restrictions are the covenants, conditions, and restrictions found in a deed. The most common public government restriction is the zoning ordinance. A house in a subdivision probably has CC&Rs. Covenants, conditions, and restrictions CC&Rs. CC&Rs all serve to control land use. They are commonly found in the declaration of restrictions filed by a developer when a subdivision plan is recorded. The deed to each buyer of a subdivision lot will include the CC&Rs by reference to the book and page number in which they are recorded. CC&Rs are commonly referred to simply as restrictions. Because they benefit the other property in the subdivision, they usually run with the land. This means that when the property is sold, the new owner receives both the burden and benefits of the CC&Rs. Creation of a formal organization of property owners, such as a homeowners association, usually is the most efficient and cost-effective method to enforce the CC&Rs. Even though the CC&Rs are recorded, they are useless unless they are known to property owners and have a practical method of enforcement. CC&Rs generally can be removed only by agreement of all those who have the right to enforce them, that is, the other property owners in the subdivision. The provisions of CC&Rs also may be written so that they apply only to the original grantee and not to subsequent owners. Covenants. A covenant is a promise to do something or refrain from doing something. Example: property owners in the Willow Creek subdivision covenant that they will keep buildings in good repair. They also agree to follow specific architectural guidelines for additions and design changes to buildings in the subdivision. If a covenant is breached, the other property owners may seek an injunction from a court prohibiting or ordering the removal of the cause of the breach, or they may seek money damages. A covenant also may be found in a lease. For instance, a tenant might promise to use the property only for a specified purpose. Conditions. A condition generally is enforceable by the person imposing the condition. In a sale transaction, that would be the seller. A condition subsequent, if performed, will enable the seller to regain title to the land. Because a condition limits the estate granted, it should appear on the face of the deed. The remedy for breach of a condition is forfeiture of the land, a much harsher result than the money damages or injunction that can follow the breach of a covenant. Because a condition can have such a severe consequence, courts will construe any ambiguous language in a deed as a covenant rather than a condition. Example: T deeded Greenacre to a local church to be used for church purposes. When the church used the land as a public parking lot, T objected, claiming the right to retake possession of the land. The court, called on to determine the rights of the parties, found that the church covenanted to use the property for church purposes. Assuming that a use was not for a church purpose, T's remedy, the court said, would be an action for money damages or an injunction to prohibit the use. A condition cannot require the performance of an unlawful act or an act that would be impossible to perform. There could not, for instance, be a condition that would require a crime to be committed or that would prohibit the sale of the property to a person of a certain race. A condition also cannot impose a restraint on alienation. A restraint on alienation is any condition that prohibits a property owner from transferring title to the property. An example of a restraint on alienation would be a condition that the grantor's consent be obtained before the grantee could sell the property. Such a restraint is void, totally ineffective, and the grantee holds the property free of the restraint. Deed restrictions. A deed restriction is a prohibition against a property use that is imposed in the grantee's deed. Homeowners associations frequently make use of deed restrictions to ensure that the uniform appearance of the homes in a subdivision is maintained. Example: J&K purchased a house in Montrose Manor, which is governed by the Montrose Homeowners Association. J&K are aware that there are CCRs on their property. They have seen the latest property maintenance standards. J&K have decided to re-landscape their property, so they are letting it go until next spring. They now have more weeds than plantings. Do they have a problem? Yes, J&K do have a problem. The property standards specify that all properties must be landscaped, trimmed, cultivated, weeded, and maintained continuously. J&K can expect to hear from the Homeowners Association soon. Covenants sometimes sound like deed restrictions and vice versa. As with a covenant, the remedy available when a deed restriction must be enforced will be an injunction or money damages. A deed restriction also may be illegal from its inception, making enforcement impossible. Expunging an illegal covenant. A person who holds a recorded ownership interest in property that the person believes is subject to an unlawful discriminatory restrictive covenant can submit a restrictive covenant modification form along with a copy of the original document with the illegal language crossed out to the county recorder. After a determination by the county council that the crossed-out language is illegal, the county recorder records the restrictive covenant modification and may choose to waive the recording fee. Termination. Restrictions, CC&Rs, may be terminated by expiration of the terms of the restriction, voluntary cancellation, merger of ownership if one individual owns both the encumbered and the benefited properties, government act, such as a legal prohibition against restrictions based on race or religion, or a change in condition that prompts a court action to remove the restriction. Subdivision restrictions often include a provision that allows their modification on approval of the homeowners association. That is accomplished by vote of all or a specified number of the homeowners. Example: Z's family has owned their home for 20 years. When it was first deeded to them by the developer, it carried a restriction that only wood shingles be used for roofing. Because of the fire hazard of a wood roof, Z and other homeowners in the development asked the homeowners association that the restriction be terminated. The restriction is modified by the homeowners association to require fireproof shingles on new or replacement roofs. In some cases, an overriding public interest in allowing or disallowing certain property uses will take precedence over a deed restriction, or even a property use limitation found in a lease. For example, sections 1940.20 and 1950.100 of the Civil Code provide that a landlord or a governing body, such as a homeowners association, cannot prohibit a tenant's or owner's use of an outside clothesline or drying rack that meets reasonable location and privacy standards. Another example is Civil Code section 4735, which has been amended to declare as void and unenforceable any provision of a governing document that prohibits a homeowner's use of low water, using plants or artificial turf. Zoning. Zoning is an act of city or county government. Zoning laws or ordinances specify the possible uses of property in a defined area. Zoning is a 20th century invention intended to promote the public health or general public welfare. It has been the subject of many legal battles involving the extent to which public interests can take priority over private ones. Encroachments. An encroachment can occur on land, in airspace, or underground a footing for a fence or building. An encroachment occurs when part of an improvement extends over the boundary line between properties without permission. Fences and buildings are typical forms of encroachment. Even the roof eave of a building can be an encroachment if it extends into the airspace of a neighboring lot. An encroaching party who fulfills the conditions for an easement by prescription or ownership by adverse possession may earn the legal right to use the land occupied by the encroachment. If not, the owner of the occupied land can bring a legal action. The decision of the court will depend on the extent of the encroachment, the relative difficulty of removing it, and whether the encroaching party acted by mistake. For example, X is an excellent surveyor but has a careless office assistant. X neglected to note that the assistant transposed some measurements on the plans for the Skyway office tower. As a result, the foundation for the tower was poured 11 inches inside an adjacent vacant lot's boundary line along the entire 200-foot width of the building. The building was completed within 2 years. 1 year after that, the owner of the vacant lot went forward with development plans and discovered the unfortunate mistake. Can that owner force the owner of Skyway to demolish the 50-floor office building or at least the 11 inches that extend onto the adjoining property? No. To do so would be prohibitively expensive, and courts will not require such an uneconomic outcome, particularly when the cause was inadvertent. The Skyway owner probably will have to pay damages for the encroachment, however. The amount of damages owed could be substantial, particularly if the adjoining property owner's plans must be extensively revised. Homesteads. California and other states provide homeowners with special protection from creditors. Some or all of the value of the owner's equity in the homestead is exempt from the claims of unsecured creditors. The homestead exemption is separate from other benefits for homeowners, such as the homeowner's exemption from property tax. Also, do not confuse the homestead exemption with the federal homesteading laws. Homesteading was discontinued after 1976, except in Alaska. Individuals may no longer homestead on public land in California as a way to acquire title. The homeowner's equity is the market value of the home less any liens and encumbrances. If the homeowner's equity is greater than the amount of the exemption, the home could be sold at the court's direction to satisfy any unpaid creditors. A sale will not be ordered if the homeowner's equity is no more than the remaining amount owed on the mortgage loan, plus the amount of the homestead exemption. If the homeowner chooses to sell the property, the amount of the exemption will be safe from creditors if the homeowner has filed a declaration of homestead and the sale proceeds are reinvested in a new homestead within 6 months. This could help a financially beleaguered homeowner. The 6-month rule could allow the homeowner to move into a less costly home, for instance, and perhaps provide some equity from the sale of the former home to pay off creditors. The generous tax exclusion rules for homeowners could allow the homeowner to avoid paying any tax on profit realized on the sale of the more expensive home. Defining the homestead. The homestead exemption applies only to an owner-occupied dwelling. The dwelling can be any of the following among other forms of dwelling: house and land, mobile home and land, boat, condominium, planned development, stock cooperative, community apartment project. The homestead can be community or separate property of spouses or registered domestic partners, or the separate property of an unmarried individual. If 2 unmarried persons share ownership, each can claim a separate homestead exemption on the dwelling they occupy. The amount of the homestead exemption. The amount of the homestead exemption depends on the county in which the property is located, as found in Section 704.730 of the Code of Civil Procedure. As of January 1st, 2021, the homestead exemption is the greater of the county-wide median sale price for a single-family home in the calendar year prior to the calendar year in which the judgment debtor claims the exemption, not to exceed $600,000 or $300,000. The amounts specified are adjusted annually for inflation starting on January 1st, 2022. The priority of claims is the order in which creditors are paid. The priority of claims against a declared homestead has been established by law. The proceeds of a forced sale go to holders of liens and encumbrances on the homestead, with any tax lien paid off first then. The homeowner in the amount of the homestead exemption only then. The levying officer for reimbursement of costs for which an advance has not been made then. Judgment creditors, and finally, if anything remains. The homeowner. If a declaration of homestead has not been filed, or until it is, the homeowner's automatic homestead exemption will be subject to any judgments recorded up to that time. A property owner has marketable title if the property is readily saleable to a prudent purchaser. An encumbrance may create a cloud on the title and impede the property's marketability. A lien is voluntary if the owner places it on the property, or involuntary if someone else does. A mechanic's lien is available to anyone providing work or material for a property improvement. A contractor's payment bond helps minimize the risk of numerous mechanics liens. If a mechanic's lien is to be filed, preliminary notice may be required to be given to the owner, the construction manager if any, and the construction lender if any. It is important to establish the starting time and completion time of the work or material supply. After work has been completed, the property owner may file a notice of completion. An owner also can stop work and file a notice of cessation. A mechanic's lien is enforced by foreclosure. If unsolicited work is performed, a notice of non-responsibility can be filed and posted on the land. The plaintiff in a legal action can ask to have the court retain title to the defendant's property by attachment even before a judgment is rendered. A court will make a judgment after hearing the claims that a plaintiff has against a defendant. The court may grant money damages, and that judgment can become a lien on property of the debtor if it is filed in the county where the property is located. A writ of execution orders the sheriff to sell the property to pay the judgment. The owner can satisfy the debt by paying it off, or can pay part of die debt and have some of the property released. A debtor's property may be taken over by a bankruptcy court. The trustee in bankruptcy holds title.